Like, if you wanted to play 52 card pickup with 100,000 decks of cards and throw them in the air, and I have to go figure out how to put them together. And by the way, the backs of every one of those cards look the same.
Guess what, y'all? The Supreme Court got a petition in the Bryan Kohberger case. It's going to be another one of those undercovered parts of the case, I guess, because I haven't seen any media reporting on this little tidbit from the hearing.
Okay, the next question I had is, I know that Mr. Kohberger filed for permissive appeal to the Supreme Court, and I just wondered what you know about that, because I had heard nothing about that. I know it was filed.
I know the state filed their objection, and that's the last that I recall seeing about it.
Yes.
Now you might be saying, wait, but didn't the judge deny this permissive appeal? Well, yeah, he did.
I do not find that the criteria is satisfied for permissive appeal. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. Obviously, denying the motion to reconsider. And with that, I think we are ready to go to setting a trial.
But the Idaho appellate rules permit defense attorneys to petition the appellate courts or the Supreme Court for discretionary review of their case through a process called petition for review. Even if a judge has denied a request for permissive appeal, this process allows for a higher court to consider taking up the case based on its discretion, and it's independent of the lower court's permissions. It's sort of like court politics. You could say that you ask the judge, and if he gives his permission, because, he recognizes that he may not know all of the nuances that are involved in a particular matter, and he can just agree, and it's less like going against the court than it is just, riding those court waves. But in this case, we had an attorney who continued with that appeal through the Supreme Court, regardless of the judge's denial. And I think that the media probably doesn't cover it because it doesn't cover like the sensationalized basis of a lot of their claims against the defendant.
So at this point, we don't know if the Supreme Court is going to take it. Okay, we don't know. You know anything else, Mr. Thompson?
Not other than the state's response was filed by the appellate division of the Attorney General's office. I think we're just waiting to hear from the Supreme Court.
Correct, Your Honor. We're just waiting to hear from the Supreme Court. I can tell you there's no deadline in the rule for them. They didn't include a deadline for themselves. And in my experience, it can take anywhere from a couple weeks to a month or so. So at this point, we're just waiting to hear.
So I don't know the answer to this. If it's filed, does that pause what we need to do here, or do we just pause it only when they pick it up?
My read of the rules, Your Honor, is the latter. That we continue as we are unless and until they decide to take it, and then they would decide at that point what exactly is paused and not.
Okay, thank you.
I would just like to point out to the court, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically is this case. Hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation.
Anything else about that, Ms. Taylor?
No, thank you, Chair.
Mr. Thompson?
No, sir.
All right.
Get a refresher of how deep the scope of this actually goes. Let's go backwards. Let's start at July 25th, 2023, when defense attorneys for Kohberger filed a motion to dismiss the indictment. Reasons were the grounds of error in the grand jury instructions, and they asked that in the alternative that they don't dismiss the indictment, that they could remand the indictment through the grand jury secrecy process and give a normal preliminary hearing. The very next month, August 23, 2023, defense attorneys for Kohberger file another motion to dismiss the indictment on grounds of a biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct in withholding exculpatory evidence. Then, come that October, on the 26th, 2023, a hearing took place to consider Kohberger's motions to dismiss the indictment. Many of them we will never get to know because they were sealed, but there were more than 24 points in the defense attorney's list of things that were wrong with this grand jury indictment. Come December 15th, 2023, the court issued an order denying the motion to dismiss the indictment for inaccurate instructions, and it also issued an order on that sealed motion to dismiss the indictment on the biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. Then, on the 21st, Kohberger's attorneys submitted a motion to reconsider the orders denying those motions to dismiss the indictment, alongside a request for permission to appeal through a permissive appeal, which would be interlocutory to the criminal trial. During the course of a criminal trial, that basically refers to decisions or orders that are made by the judge during the course of a trial or pretrial. The court inevitably held a hearing on those latest motions, and the initial segment of this hearing was closed to the public and allegedly discussed content sensitive to the grand jury's confidentiality. The subsequent portion was publicly accessible and deliberated aspects of the motions and reconsideration arguments that did not breach grand jury secrecy. Ultimately, they would all be denied, and in this denial that the judge issued, he would concurrently deny a motion that defense attorneys actually filed in an attempt to get the court to unseal a part of Kohberger's filing that they inevitably apparently wanted the public to be able to access. Public opinion being kind of a big deal, especially in high-profile cases like this. I really believed that this would actually be unsealed. For one thing, it was an incomplete motion in the first place. The motion doesn't specify the subcategory that would actually make it a sealable document. So it's an incomplete motion on its face, and defense attorneys actually showed a bit of confidence whenever they filed asking the judge to unseal this. They confidently stated they had told prosecuting attorneys already to be expecting that it would be unsealed with the court. Not if it might be or that it could be, but that it would be. Well, inevitably, they held a hearing on that. That was also held in secret, of course. So concurrently, the judge denied the request to reconsider. He denied the request to file permissive appeal, and he also concurrently shot down the motion to unseal that record, even though Ann Taylor states in that record that it's prejudicial to Bryan Kohberger's case for this record to remain sealed. She states that it doesn't have any info that would typically fall under the guidelines for being a sealed document, but apparently the judge disagreed with that. In that order, he references sealed discussions, especially on the grand jury secrecy, influencing decisions on the document's confidentiality, and says that that is basically why they're not going to unseal it. And in the court's analysis in this 8-page document denying the reconsideration as well as the permissive appeal, they stated their reason for denying the reconsideration allegedly were grounded in established case law. They stated the constitutionality of the statutory provisions behind it and stated that the court found no factual or legal errors in its prior decisions. And it also denied the permission for appeal under assertions that the issues raised do not meet the threshold for substantial legal questions or public interest that would warrant an appeal. And it emphasizes that an appeal would delay proceedings without significant benefit to the defendant or judicial process and could prejudice both parties given the potential fading of witness memories. Now, check out this part. We hear Bill Thompson stating that he was ready for trial this summer. And then during this hearing, he comes back and actually states that he'll be done giving defense attorneys full discovery by the same timing. So that timing went from we'll be ready to like, we're not even done disclosing discovery material to defense attorneys.
I've heard the court say the court only wants to do it once. And I've heard the court ask, what can I do to speed things up? I need discovery. I need all of the discovery. I need the things that we've asked for. I need to not have to fight in motions to compel for things that was done on behalf of the state by the FBI that ends up being used against Bryan or used in the investigation. I need that stuff. When I ask for something, I need to get it rather than have to go back and ask and ask and ask again. I'm not saying anything mean about Bill Thompson. I'm just not. I think he tries his very best, but I think he's hampered by the agencies and the information he gets from them. I can give you some examples. We asked for X-rays. We were told they don't exist. They're listed repeatedly in reports. We asked for them again. And I'm not sure if I'm getting them or not. The response is we have thumbnails, but we haven't found the actual X-rays. There's one example.
And we were initially told, no, you don't have that. And then we have gone back at the prompting of defense saying, you sure? I mean, it ought to be there. And for example, X-rays for the autopsy. Well, we just got those. The first came in with thumbnails. In today's discovery, Ms. Taylor's going to have the full size, which we were able to obtain when we saw he gave us thumbnails. These are useless. Give us the real thing. And through the coroner's office, we were able to finally achieve that. According to Ms. Jennings, we are better than 95% complete on discovery. So we're getting close. There are some things that are outstanding. There are some issues with what information is actually available to us. We have given Mr. Kohberger everything that we haven't asked for a protective order on or had some sort of dispute about. And we've given it to them, and frankly, in the order it's come in, instead of waiting to try to package it together and give it to them in a different format, just because they want it as quickly as possible. And I appreciate that. And we're going to continue doing that. It's going to benefit to have deadlines for everybody to have to work for here.
Why would prosecuting attorneys have not even had the autopsy pictures in their possession, the autopsy X-ray pictures? Well, that's a good question. And they kept alleging that they don't exist, and defense attorneys kept pointing out, yeah, they do exist. They're in multiple reports. They're being referred to multiple times. And defense attorneys totally copped to this and state, they went back and they were able to get those, and that defense will have those as of some time after this hearing, because apparently before this hearing, they did not have them. And defense states this during the hearing, to which prosecuting attorney informs her again during the hearing that they actually will have the full autopsy x-rays soon. Now, this makes me wonder if a part of defense attorney's alternative narrative will involve multiple killers or multiple weapons being utilized, or maybe even a weapon that's not the K-bar knife. Who knows? But I know that wanting to see how the bones were affected would be a big part of a defense play in that region.
So maybe a few months later, I get some photos that has these screenshots in them. And now I have to try to figure out who gave that screenshot, whose phone did that come from, which officer did that interview, and get them matched up and figure out if it's somebody I need to talk to. So not only do we have a huge volume of information, the way I get it is completely disorganized. And it's like if you wanted to play 52 card pickup with 100,000 decks of cards and throw them in the air, and I have to go figure out how to put them together. And by the way, the backs of every one of those cards look the same. That's what I'm doing. We also have science questions in this case. We have DNA, we have cell phone analysis, we have video analysis. The video analysis that the state really likes in this case, I don't have the full scope of that video with audio that should be available. They're working on it. They really are. I don't think they're not working on it. I'm just saying this is a real thing that takes time. And then you have the public nature of this case, and people don't want to talk to us. They're not running to talk to us. So we have to try to get witnesses, people that are listed in the state's discovery, to talk to us. We have our duties that are required with mitigation because there's no break.
Something's not adding up, as always, as usual in this case. Another issue that was ruled on was defense experts could review the IgG information, but not defense investigators. So it was kind of odd because actually in the prosecuting attorney's paperwork, they stated, that they object to this altogether, but that at the very least, the judge should specify that the defense attorney should have to include the names of the criminal investigators that would be viewing this information.
Reading the state's response, I think the state has no objection to the three named experts having access to the sealed IgG materials or the materials subject to protective order. So I think what we're really talking about is our investigative team for Bryan's case to have access to the IgG materials. And the state has objected to that. They've objected in part because they are not named in our motion. So I want to address that first. Your Honor, they are not named, and I can name them, that's not a problem. But the reason I didn't is based on consistency. These same investigators have had access to the grand jury materials to assist us in the case. They've had access to other things subject to protective order, and they're not named in those. They have access, there's three items subject to other protective order, and that's medical information from hospitals, that's University of Idaho records, and most recently, police procedures. They haven't been required to be named in orders in any of those. And so for consistency, I did the same thing. But we can name them if that is a sticking point. I would note that the members of the FBI that did the analysis are not named in the materials either. Your Honor, the reason why our investigators are important to have access to the IgG materials is because of the kind of case this is and the kind of investigation that we're required to launch in the case. We have to have investigators on a death penalty case, and we have them. These materials or these items in the IgG binder, those are things that we may end up filing motions in court for. In order to prepare for those, we rely on our investigators to help us with side tasks, with big tasks, with all of the tasks. We would need to utilize our experts.
The judge completely sides with prosecution on this and rules that only defense experts, let's just go ahead and get your experts working on it.
If our investigators can't have access to the materials. They'll have to be shut out of those meetings with those experts, and they'll have to be shut out of court proceedings that we might launch related to those materials.
And actually indicated that he would need further justification for allowing their investigators to actually access that.
For right now, I would say, let's just get your experts looking at the IGG stuff and exactly what they can read from that. And we'll go from there.
I asked for certain mapping data done by a member of the CAS team. They said, you have it all. I said, no, I don't. I only have November 29th. And they said, oh, well, I guess we just didn't get that. Something didn't copy right. And I'm not saying anything mean about Bill or his office. I'm saying this is really difficult to drag the information out and get it to my experts or to understand it. And to hear that we're going to have a discovery deadline by the end of August is great. I need to have every piece of everything. I then have to have time to double check and make sure I really got it. I need to have time to get it to my experts and for them to have an opportunity to understand how that impacts their opinions, if at all. So I'm prepared for this case. And then we need time to get things to the state and for them to respond to what we send to them too. I know that this court wants to set this trial. These kinds of cases don't happen in a year. They don't happen in 2 years. They take a long time. This case is challenged with the way discovery has come at us. I'll give you another example. I get them and I list them in my computer by date. At one point, I gave the court a printout of that so the court could see how I'm getting it. And when I look in a folder, it has subfolders. And I might get some reports from Moscow Police Department with an FBI report. And an FBI report might reference an email. It might reference a photograph. It might reference a screenshot of a picture or of a phone that they took when they interviewed somebody. That's not with it.
But yet again, I mean, this isn't rocket science. This is something that they claimed that they already had done in order to arrest a defendant. Why the hell would it take this long? I saw a big uproar and people losing their minds, stating Anne actually stated that she didn't want to disclose the rest of the alibi defense because yet again in this hearing, prosecuting attorneys were really sweating Kohberger turning over the rest of the alibi. And John Judge acts like a complete and total derp. And it was like, I'm sorry, I guess I dropped the ball on that. Yeah, I guess you did, because it was literally brought up in the last hearing that, that just couldn't be, with Anne multiple times in not only a written motion, but in a hearing the last time that we heard, she mentioned this very thing. She was like, no, Your Honor, this cannot be, that we only have said deadline that they are trying to restrict us with because they've not even completed full discovery, and the deadline that they mentioned we've already missed was a part of a order that was vacated. Judge John Judge pretends like he didn't even hear this, and this is new news to him. Totally another weird ass part of this whole debacle. Very strange. I cannot wait to see what Supreme Court has to say, especially since it pertains to some form of prosecutorial misconduct and the possibility of withholding exculpatory evidence. I do think that that's going to have something to do with the prosecuting attorneys rushing to get that indictment, while defense attorneys stated through their experts, they didn't state that Bethany Funk might have exculpatory evidence. They stated that through their investigatory process, they had uncovered that she did have some type of information that was unique to her experiences, which would provide exculpatory information for Kohberger's defense. Was it the prosecution's indictment was rushed in order to negate them being able to actually get that information to the court and not actually hearing those specifics from a witness during the grand jury indictment? Now, unfortunately, I did go about looking for these. I went and checked the Supreme Court docket and tried to see if any of these matters were published. And I've drafted up a note that I'm actually writing to the court clerk in order to clarify, is this permissive appeal under a particular seal, which would keep us from being able to read the basis thereof from the public aspect of this case.